Minister, Madame Senator Batters, followed by Monsieur Senator Dalphon.
Thank you. Minister Gould, the Liberal government tries to defend allowing the use of the Elections Canada voter information card as identification by saying that it has to be accompanied by one other form of ID, and you did this again today. But however, with those voter information cards, they're riddled with errors, 1.6 million error-riddled cards in 2011 by Election Canada's CEO's own estimates. And that could form the only address identification that's needed for a voter. Then a voter only needs to show a second form of identification with their name only and no address. And you're also allowing identity vouching to be used for that person to prove their identity. So that person could vote in an election with no actual identification, only an information card, which may have been printed and sent by Elections Canada in error. Why has your government stripped away those crucial protections that our Conservative government put in place to safeguard our democratic system so that someone with no actual identification with their address and only a voucher for their identity can vote under Bill C-76?
Have you ever scrutineered?
Absolutely.
So have you sat there and watched someone be turned away from voting?
Actually, I scrutineered and spent all day in the polling stations last election with significant identification required, but with many different types of identification allowed. And what I saw all day long at all polling stations is more people than ever coming to vote and no problems witnessed.
So I have scrutineered before, and I have, watched as an individual who came and was vouched for. And it was a dignified process. It was a process in which there was integrity. The person who's vouching swears an oath to attest that they are confirming this identity and the residency of the individual. This was an individual who was one of our more vulnerable in society, right? And to say to that individual that we would not allow them to vote because they don't have a piece of identity seems wrong to me. Because it's a Canadian citizen, they have a right to vote. And so we're talking about our most vulnerable citizens who we should be encouraging to vote, because the policies that we're making here in Ottawa are the ones that have the greatest impact on them. With regards to Elections Canada, they do an incredible job at maintaining the integrity of our system. Despite what Conservatives have said about voter fraud, we don't have instances of voter fraud widespread in Canada. In fact, Elections Canada does an incredible job of maintaining a registry of millions of Canadians. 10 million Canadians move between election cycles. That is an incredible amount. But those Canadians are able to cast their ballots, and Elections Canada does an amazing job of doing that. For me, when we're talking about homeless individuals, when we're talking about that senior citizen that I referenced earlier, when we're talking about university students, these are people who should absolutely be voting, and we should be doing everything we can to encourage and enable them to cast their ballot, because their voices matter. Okay. I do not believe Minister, we should be limiting their right to cast their ballot and to participate in a democratic society.
Right, and we did allow vouching as well. Minister Gould, Bill C-76 proposes to return the Commissioner of Canada Elections to the Office of Elections Canada. We separated those critical functions. Your government has returned the Commissioner to, as you stated in your opening statement today, to, quote, report to Elections Canada, quote. Previously, the Commissioner of Canada Elections was within the Office of the Director of Public Prosecutions. Now the Commissioner will be an employee of Elections Canada. So, Minister, certain offences in Canada's Elections Act could potentially be committed by Elections Canada officials or employees. And if that happens, who would investigate those Elections Canada officials or employees, and who would prosecute those offences?
So the wording was report through the CEO of Elections Canada, as opposed to report through a cabinet minister, which is an important distinction to be made, but it is very clear that there is independence between those offices. However, again, if Honourable Senators, and I'm sure you did, read the recommendations from the CEO following the 2015 election, that it was recommended to put the Commissioner back into the same housing as the CEO of Elections Canada,
could you answer my
as
question
well
about
as
who
with
would
regards
investigate and who would prosecute,
as well as with regards
officials?
to taking it out of the Department of Public Prosecutions to ensure a timely ability for the Commissioner to be able to prosecute. And Section 509.21 is with regards to independence. It says, all decisions made and actions taken by the Commissioner under any provision of Part 19 are to be made or taken independently of the Chief Electoral Officer.
But Minister, who would investigate those Elections Canada officials or employees, and who would prosecute them? It would be the Elections Commissioner, right?
But it is not an employee.
Is that correct?
In the context that you're trying to frame it, it is simply to enable them to be housed together and to be able to ensure independence from government, which is extraordinarily important.
Minister, what if in the worst-case scenario,
Quickly,
the
Senator.
Chief Electoral Officer himself potentially committed an offence under the Elections Act? Who would investigate that? Who would have the power to compel that CEO's testimony, and who would prosecute it? And when you say Elections Commissioner, he will be under the office of that Chief Electoral Officer under your bill. So wouldn't that really be the Chief Electoral Officer investigating himself, deciding not to compel himself, and prosecuting himself?
They are still separate, and the Commissioner, as I stated, is independent of Elections Canada. However, should the Commissioner choose, he could hire a separate investigator to do the investigation.
But it's no longer under Director of Public Prosecutions.
And that is a very
correct?
important thing to note, that it is no longer under the Director of Public Prosecutions, so that the Commissioner can undertake timely investigations and to ensure that charges are laid. And in fact, one of the other things in C-76 that I mentioned in my opening remarks is the ability to compel testimony. We are trying to empower the Commissioner to investigate and to ensure that fulsome investigation is done and able to then be able to prosecute elections offences, something that when it was under the Director of Public Prosecutions would take too long, and then they would not have to be able to maintain. I highly recommend you ask the Commissioner these questions, because it is very compelling as to why this change needed to be made to ensure the integrity of our electoral system.
Thank you.
Okay, Senator Delphine.